the proposed amendment to Section 31 of the Employment Act to compel employers and employees to contribute 1% of gross pay to the National Housing Development Fund. The employers are opposed to the proposed amendments to the Employment Act contained in the Finance Bill 2018 and the budget statement to compel employers to pay 1%, or is it 0.5% as contained in the budget speech of the Cabinet Secretary to Treasury on employees' gross monthly pay. We are opposed to these changes for the simple reason that the proposed changes increase labor costs and also the cost of living for employees. As you are aware, the proposal increases both the labor costs for employers and the cost of living for employees without any guaranteed benefit to the workers. As you know, that employers already provide housing and pay housing allowance to employees of at least 15% of the employees' basic pay. The proposed amendment does not indicate or say whether this contribution will be in addition to the housing allowance or whether it shall be deducted from this benefit. Secondly, the proposed changes do not indicate or say what the employers and employees will benefit from these contributions. We are also not aware what informed the percentage that is being proposed. There is confusion whether the contributions are 1% or 0.5% of the emoluments that employees get.
With regard to the labor laws, we do oppose entirely all the proposed amendments because they are ill-informed. They do not actually improve the governance of the labor sector, but will expose our economy to a lot of industrial unrest because these laws seek to remove the oversight role of the Ministry of Labor in some cases. They seek to change the law on strikes in essential services, which are currently prohibited, to actually allow strikes in essential services, when we would have thought that what was needed was to come up with a very clear structure of managing disputes and issues that come from the labor sector, especially in essential services, to facilitate speedy, amicable resolution between the parties of the issues and avoid court action. To allow strikes, particularly in essential services, in our view, is counterproductive. We are concerned also that far-reaching changes can be introduced by way of a miscellaneous amendment, when actually the changes proposed amount to a complete overhaul of the piece of legislation. So what should have happened if there was proper consultation was, first of all, to agree on what needs to be changed and to amend the substantive acts themselves, instead of producing far-reaching changes through miscellaneous amendments, which is not the correct thing to do.